Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real life cases, real life clients. They are things that me or my office have actually worked on. For today's episode, we're going to be talking about kind of a general topic, but talking about the topic and takeaways by sharing a cautionary tale. And the topic we're going to be talking about is estate planning after a divorce. And honestly, things someone after a divorce need to think of and proactively do. So let's get into it. Let's get into today's cautionary tale. To set things up, there are really three people involved in this real life cautionary tale. Let's name them, let's say Steve, Barbara, and Heidi. So Steve and Barbara were once married, and Heidi is Steve's daughter. So to clarify and confirm, Heidi is not Barbara's biological daughter. Now, Steve and Barbara got married several years ago, like in the mid-1990s. And to be honest, Steve and Barbara had a fairly estranged relationship with Heidi for some very personal and very specific reasons. Fast forward to just a few years ago, divorce was filed for, and both Steve and Barbara had attorneys represent them during and through the dissolution of their marriage. Part of the process, of course, was coming up with an agreement on how their assets and things were divided. Ultimately, that was decided, and a settlement agreement was signed and filed with the court. Now, part of this settlement agreement, there was a section in it called Waiver of Beneficiary Status, which is going to be really important to remember as we dive into this story. So I'm actually going to read you what this provision says. So in this Waiver of Beneficiary Status provision, it says, each party waives any beneficiary interest that he or she may have in any life insurance policies, annuities, brokerage accounts, pay-on-death bank accounts, individual retirement accounts, or other instruments containing a beneficiary designation that are now owned by the other party. I sure don't do family law and divorce in my firm. All I do is estate and elder law. But I'm going to assume that this type of provision is in many settlement agreements. And if not, it probably should be. So if you pursue a divorce, maybe make sure something like this goes in your divorce decree. Steve and Barbara's divorce was finalized and everyone sort of moved on. Though Steve and Heidi's relationship as father and daughter remained fairly estranged. As Heidi told me once, when my dad kept bringing me nothing but negative, bad things into my life, I just had to stop and separate myself from him. And in my conversations with Heidi, honestly, it didn't feel like there was like a deep hatred or, anything like that. It was simply that Steve had made some personal decisions that would consistently and deeply affect Heidi emotionally. And as she said, she got to a point where she felt like she needed to separate herself from that negativity. So about 2 years after the divorce was final, Steve ended up passing away. He was younger when he passed away. He was in his late 50s, if I remember correctly. And, it was a dose of unexpected. It was unexpected due to his age, I guess. But I would imagine Heidi was not quite surprised given Steve's choice on how to live his life. That's about the point that Heidi entered into my world. She reached out to my office to have us help her get through, what happens after someone passes away. So I meet with Heidi, and after learning about her and her father's relationship, I assumed and confirmed in the meeting that she really did not have much information yet on Steve's assets, like how they were owned, what beneficiaries were attached, etc. But what we did know for sure is that Steve had a house, and that house was in his name alone that was going to cause us to have to open up a probate estate. In this meeting with her, I asked her about a will and whether she had any idea if he had an estate plan. She really had no idea, and she actually lived out of state and said that she would be in town over the weekend and would look high and low for a will or any kind of estate plan. So as we were wrapping up the meeting, I told her that even though we didn't have any answers on his other assets or whether if there was even a will yet, that we might as well get started on getting the probate case open just to get things rocking and rolling and moving. So after the meeting, we start working on all the court paperwork, and eventually after a few days and when Heidi had gotten into town, she confirmed that so far she had not found any will, anything like that. And she further shared that his house was a total and complete mess, though, so if she ended up finding anything, she would let me know. Fast forward some time, no will was ever located. Heidi, in kind of due diligence, even called the attorney that had represented Steve in the divorce to see if that attorney had maybe done an estate plan for him. Nope. So we proceeded with filing for an intestate probate case. So here's a quick little lesson for you. There's something called intestate probate and testate probate, two different things. So intestate means that the person that passed away did not have a will. And testate means that the person that passed away did have a will. Nonetheless, both intestate and testate, that's a mouthful, both types of estates go through probate. So here, we filed for opening a probate case for an intestate estate since he had no will that was at least located. We get the estate rolling, and about this time, the estate case gets opened up. Heidi's been in town cleaning out the house, calling financial companies, etc. And she called my office to relay some news. So after talking to two separate financial institutions, one for Steve's retirement account and another for Steve's life insurance policy, both institutions confirmed that the listed beneficiary on the asset was Steve's ex-wife, Barbara. Dun, dun, dun. Well, Heidi's a smart cookie, very intelligent woman. And really before she even told me, she actually provided the divorce decree to both of these financial institutions to basically say, like, hey, look, they waived being each other's beneficiaries on assets. Like, can you just, skip over Barbara? Well, the financial institutions basically said, sorry, we see that in his divorce decree, but, so we don't get sued by Barbara. We're going to need a court order to tell us to not issue these accounts to Barbara. So that's what prompted Heidi to call me and basically say, help. Around this time, I'm going to guess that Heidi making these calls to the institutions triggered the institutions into sending a letter to Barbara to inform her, Barbara, that she was actually the designated beneficiary. And Barbara proceeded to file claims and collect the money from the retirement account and life insurance policy. So that ticked Heidi off, to no end, right? Of course. You see, I know my wheelhouse, and filing a complaint against Barbara to seek recovery of her collecting the proceeds, is and was not my skill set. Could I have figured it out? Sure. Would I have been sort of stumbling through it? Yes. So anytime I feel that way about something, I bow out. If I can't do something at 110%, then I don't do it, and I should not do it. That's just how I roll. So I asked a friend an attorney friend who does estate litigation to assist me. I ran the scenario by him, and he was like, yep, I know exactly what needs to be done. See, that's the confidence Heidi deserved, right? So Heidi agreed to get him on board, and away, they went, him and this attorney. Him and Heidi. Unfortunately, how many things in the legal world work, Barbara and Heidi ended up reaching a settlement. At the end, Barbara ended up getting to keep some, and Heidi, through the estate, would end up receiving some too. I think a lot of people would think, well, there's that provision in the divorce decree. Why doesn't that just hold up? And I wish I could say I agree. But to enforce that provision would probably require more or significant court involvement. And eventually the legal fees would end up consuming most, if not all, of the money at stake. It's sort of the sad reality of our current legal system. It often encourages settlement rather than coming to a clean, you win, you lose sort of scenario. Because getting to the you win and you lose conclusion requires so much court involvement and legal fees, honestly, that's just the way it panned out. A perfect counter argument to this divorce decree provision and really against Heidi is, what if Steve meant to leave Barbara on there? He was estranged from Heidi and didn't really have anyone else. So maybe he just thought, oh, heck with it. Let them duke it out later. We don't know. And we'll never know what Steve's intention really, truly would have been. So we just have a couple minutes left for this episode. So, as you can see, after a divorce, there are some housekeeping things that you should consider from an estate planning perspective that I want to talk about as takeaways here. First, if you and your spouse get a divorce and you guys have done an estate plan, somewhat immediately, I would consider updating your really basic documents like healthcare representative and advance directives and your financial legal power of attorney. That way, if something happens to you in the middle of the divorce proceeding, and trust me, I've seen that happen, then your soon-to-be ex-spouse is not your designated healthcare decision maker or your designated financial decision maker. That would be awkward. And second, after the divorce proceeding, or even when maybe it doesn't have to be necessarily super closed up, but maybe you're on the really tail end, you need to add it to your to-do list to get your will and or trust, estate plan updated. Now that assets have been divided as the decree stipulates, it is vital to get these documents updated or created. And while you're in this deep dive in your assets and what happens to them at your passing, be sure to check each and every beneficiary designation, my friends. If you think you've updated it, check again, just to make sure. It just takes a few minutes. Like Steve here, it seems he left his assets exactly as they were before the divorce. Is that what he wanted? We'll never know. But regardless, it sure caused a mess, didn't it? Given what the divorce decree said and what his daughter Heidi tried to push for. I know this season of life may not be the most fun in the world, but please, please, please add, checking, updating, or creating your estate plan to your to-do list. Do it during and or following a divorce so that when you're on the other side with all things legal, divorce and estate, you can put this whole divorce behind you and to rest and move on with peace of mind. Alrighty, let's wrap this episode up and shift to a sneak peek of next week. We are back to the current events, current trends topic, where we talk about something I've seen or run across, maybe on the news, social media, who knows. Nonetheless, that I think would be interesting to chat about on here. So during next week's episode, we're going to dive deep into the topic of elder law. And while I've talked about it very briefly here on Legal Tea, like in and out of episodes is what I mean by that, we're going to be talking about what even is elder law. So many people don't know what it is. And, whether you need an estate attorney, whether you need an elder law attorney, or maybe you need someone that's skilled in both. I'm going to talk about it under a current trends episode because while elder law has been around for a bit, I still don't think people really know what it is, and everyone should. So, we're going to be talking about that next Tuesday, Legal Tea listeners. So until then, take care and be well.